Hello everyone, and welcome to the Cannabis Crossroads webinar series, generously supported by the Conference Fund at Memorial University. My name is Dina Gayed, and I'm a postdoctoral fellow with the Cannabis Health Evaluation and Research Partnership Team, or SHERP. We are a multidisciplinary team based at Memorial University, funded by the Canadian Institutes for Health Research and the Canadian Centre for Substance Use and Addiction. We have investigators in pharmacy, medicine, education, and psychology, and a wide range of external stakeholders on the advisory panel. Some of those members are here presenting to you today. We will begin today's event with a land acknowledgement. We respectfully acknowledge the territory in which we gather as the ancestral homelands of the Beartech, and the island of Newfoundland as the ancestral homeland of the Mi'kmaq and Beartech. We would like to recognize the Inuit of the Ninunsiovit and the Ninunchikavut, and the Inuit of Sinan as the ancestors and the original people of Labradors. We strive for respectful relationship with all the peoples of this province as we search for collective healing and true reconciliations, and honor this beautiful land together. Please welcome our facilitator for today, Dr. Lisa Bishop. Dr. Bishop is an associate professor in the School of Pharmacy at Memorial. She is one of the principal investigators on the SHERP team. Welcome, Dr. Bishop.
Great, thanks, Dina. And thanks everyone for joining us today for our discussion about cannabis use in the workplace. So our SHERP team has been examining cannabis policy in this province, and this first involved engaging with the public and stakeholders to help us identify priorities for our evaluation. So during this process, we realized that there was a need for public education. So that's why we organized this Cannabis Crossroads webinar series to help provide this education to the public. So we have a wonderful panel of experts today who will be discussing employers' and employees' perspectives on and responsibilities for keeping the workplace safe, while also recognizing that some people require cannabis for medical purposes. So today we have Dennis Hogan, who's the CEO of Workplace NL, Carrie Majid, Executive Director and Legal Counsel of the Newfoundland Labrador Human Rights Commission, and Paula Shump, General Counsel of NAPE. So before I turn it over to our panelists, I'll start with a few housekeeping items. So for those of you who are new to WebEx, there is a layout button towards the top right-hand side of your screen that gives you options on how to view today's presentation. We will be holding a question and answer period following the presentations, so please submit your questions through the Q&A box, as we will not be offering the option to unmute yourself to ask questions. You may also submit your question at any time, and they'll be addressed following the presentation. My colleague Sandy Brennan will be monitoring the Q&A, so please try to keep your questions short, and I encourage you to post your questions as soon as possible. So please keep in mind that while we're discussing general concepts about cannabis in the workplace, our panelists are unable to provide medical or legal advice for specific individuals. So keep this in mind when posting your questions. This session is also being recorded and will be available to view online on our website following the session. So now we'll get started with the presentations. It's my great pleasure to introduce our first panelist. So first up is Dennis Hogan, and he has been the CEO of Workplace NL since 2016. One of his roles is navigating the evolving occupational health and safety issues facing workplaces in Newfoundland and Labrador, including the legalization of cannabis. He also worked as an employer's advisor with the Newfoundland Labrador Employers Council, and he holds a Bachelor of Arts in Economics and Business from Memorial University and a Master's of Business Administration from MIT. So thanks, Dennis, and I'll turn it over to you to get started.
Great. Thanks so much, Lisa. Appreciate your kind introduction. I am delighted to be here today to join everyone and my co-presenters to talk about a very important topic, And hopefully we can leave you with some insights on the impact, particularly as it relates to cannabis in the workplace. And I should just mention for everyone, I am the CEO of Workplace NL. So Workplace NL is the Workers' Compensation Board here, the provincial board here in Newfoundland and Labrador. And we kind of have a dual mandate. So, of course, we compensate people for work-related injuries and illness. But we also have a big mandate in prevention, in creating awareness, setting training standards, things of that nature that really try to prevent such injuries and illnesses from happening in the first place. And that's really where a lot of our work around cannabis in the workplace has taken place since legalization several years ago. And I'd just like to start by indicating that we did engage in a significant provincial campaign. So we partnered with the provincial government in the lead up to the legalization of recreational use cannabis. And that really, the intention there was to educate workers and employers throughout the province on what to expect when cannabis use was legalized. And our message was very, very simple. It's not okay to be high at work, and being impaired is a significant health and safety risk, not only to you, but to everyone else at work. And you would think that that would be a fairly intuitive message, but we did get a fair number of requests and inquiries about this very subject, whether or not people are allowed to use recreational cannabis at work. So another big question that arose was, and we were anticipating a lot of activity in this area, and sure enough, we did get a lot of employers, businesses, employer associations that were coming to us looking for some guidance. And I think we all had a collective feeling that this was a very significant change for the workplace. But really, when we stepped back and legalization happened, we realized that the responsibility for employers and also for workers in the workplace didn't really change with the legalization of recreational use cannabis. Employers and supervisors still had the same responsibilities that they had before, but because workplaces really had to consider and have policies and practices to deal with impairment at work from alcohol or drugs, whether they be prescribed or illicit. What they did have to do with the introduction of legalization was to update those policies and procedures to recognize recreational use cannabis. So it's just part of an employer's responsibility to protect the health, safety, and wellness of employees. And I should mention as well that employers are also required to accommodate employees with medical needs or disabilities, and that includes disabilities from substance dependence. So key to this would be a good impairment policy that an employer should have in place. And they have to recognize that working while impaired through whatever means, including cannabis, is not safe. It's not a good practice. So introducing a good impairment policy would clearly outline how to identify and report impairment to ensure the confidentiality of employees and state under what circumstances, if any, that such substances would be permitted on the premises. And that policy should also list that help is available to employees who are dealing with substance issues or have questions about cannabis, when employees will be accommodated for or considered for accommodation. And if applicable in a given workplace, it should also address the circumstances under which drug testing would be administered. And this may be required for certain safety sensitive job sites or jobs, specific jobs. Just one example I could think of is if you're a pilot or in the military, I believe they do regular drug testing. And the final point I'd make on this is that the employer then has to provide the appropriate training to employers, supervisors, and managers so they understand and are aware of this particular policy around impairment.
Hi, Dennis. Sorry not to interrupt for a second. I don't think you started sharing your slides with us. I was thinking you were giving us a bit of an intro, but I think you are walking through your slides, are you?
I am actually. Sorry, I thought the slides were showing through.
No, we didn't start to share after I passed you the presenter. But if you can pop them up, we'll get them from here.
Okay, I'll try that again. Sorry about that.
It's all right. Thank you.
Okay, can you see those now?
We do have your present. Yeah, now we go. Now we have
Okay,
them.
sorry
Thank
about
you.
that. Yeah, of course, I was going on thinking that you could see the slides, so
Yeah,
my
absolutely.
apologies.
Stop
So
you while we
I
can.
won't spend, yeah, no, I had about 10 or 15 minutes, so I won't recap sort of the things that I was speaking about earlier, and these slides will be available to anyone who wants them. In addition to that, as was indicated earlier, that the session will be recorded. So essentially, I gave a bit of a summary on each of those issues around employer responsibilities. That didn't really change a lot. Talked about a good impairment policy and what that means, and just really to conclude on, did employee responsibility change? And that didn't really change either. So an employee, their role in the workplace and as it relates to safety didn't change when recreational cannabis use was legalized. And in short, employees always have to work safely, not endanger themselves or others on a work site, follow company policy, report unsafe work to their supervisor. And I think an important point to close on is that you do not have a right to recreationally use cannabis at work. And I'll just emphasize too the point about those individuals who are on safety sensitive jobs, such as heavy equipment operators, delivery drivers would be another one. They really have to pay particular attention to not being impaired at work. I mean, it can be a matter of life and death. And it's not safe to work while impaired. It may affect your motor skills, your judgment, your attention, your perception, and all of that can impact your ability to do your job. So that was kind of the comments I had for my kind of opening remarks. And again, apologies about the slides, but they are available to anyone who may want them. And I'll end that now.
All right. No, that's perfect, Dennis. Thanks. And I mean, you provide some great, I guess, initial kind of background in terms of employer-employee considerations around cannabis. So that was great. So next we have Carrie Majid, who is the Executive Director and Legal Counsel of the Newfoundland and Labrador Human Rights Commission. So this is an independent at arm's length government agency that is responsible for promoting an understanding of, acceptance of, and compliance with the provisions of the Human Rights Act. So Carrie holds a Bachelor of Arts from the University of Waterloo and a Bachelor of Laws from the University of New Brunswick. And she has over 20 years of legal experience and was recently elected as a bencher of the Law Society of Newfoundland and Labrador. So thanks so much, Carrie, and I'll let you start to share your slides and you can take it from here.
Let's hope I did this right.
Yep, that's good.
You can see me?
We can see you. I just put in presenter mode. There you go. Perfect.
How's that?
That's good. Thanks.
Okay. So I'm going to follow up on some of the things that Dennis was just talking about. Just briefly, I don't have that long of a time, and I can't see my watch here, so just keep me on track, please. The Human Rights Commission, again, very simple. What we do are investigate and resolve human rights complaints, and also do public education and talk about human rights in the province. I'm going to skip over some of these because I don't have a lot of time, but essentially, in order to file a human rights complaint, you need to show that it's reasonable to believe that you were treated unfairly here in the province, and that most of our cases are at work, and that you were treated unfairly because of one of your personal protected characteristics. They're called prohibited grounds in the Human Rights Act. So as Dennis said, recreational use is not protected under human rights legislation. However, medical use or addiction, which can be considered a disability, is protected. That doesn't mean that you can work and you can be at work and be impaired for any reason. So, just because it's protected doesn't necessarily mean people get to do whatever they want to do. Recreational use should be treated the same way as alcohol or any other drugs which cause impairment. And smoking or vaping cannabis, either recreational or medicinally, is prohibited anywhere that laws or rules prohibit smoking. So that's under the Smoke-Free Environment Act in workplaces. So again, there are a lot of different overlapping rules and pieces of provincial legislation that deal with this particular subject. So just kind of an overview, you know, this is what I've heard from employers. It's the cost and time involved with training staff, HR people, you know, security, whoever it is, to learn to recognize signs. Don't make assumptions that it's alcohol or drug related. There may be other explanations, and these are all built into your policies that I'll talk a little bit about later. Sometimes, though, immediate action may be required where there's, say, an accident or a near accident and impairment is suspected. If there's a serious impact on the workplace or it is a safety risk, an immediate safety risk. So, you know, again, a lot of different factors that people need to think about. I'm going to skip over this. Again, I don't want to waste too much time. But here, the underlying premise is that, you know, there are protected rights that we all have. Employers have an obligation to accommodate people to the point of undue hardship. It's called reasonable accommodation for a reason. That means it's got to be reasonable, but also employers have a high burden to show that they've met this duty of undue hardship. All accommodation should be built on the principles of dignity, individualization, and inclusion. They must be considered on an individual and case-by-case basis. All parties, including unions, have a duty to participate. And people's needs may change over time, but they're not unlimited. So for example, if somebody has an addiction issues, you may need to accommodate them in a short and medium term while in recovery, but then afterwards, once they're out of that program, there may be different types of accommodations that need to take place. And the duty to accommodate has a procedural and a substantive component, which means the process that employers follow in order to I guess, make sure that all accommodation options are considered is just as important as the end result. These are some types of accommodations. Now, what we tell employers all the time is really be creative, change your mindset about accommodation. It is a legal obligation, obviously, but sometimes it's just about providing supports to people to allow them to work and to do a good job. So, I mean, I think we all want that from employers. And if I mean, this is a little bit of a different case because there are such safety concerns, but for the most part with accommodations, we find if people look at it at how can we support our employees rather than this is an legal obligation that I need to, you know, this form needs to be filled out. Then we go through this process and then this process, and then we have this stalemate for a long time. It seems to work a lot better. So some types of accommodations in this area with respect to medicinal or the use of cannabis, you know, there might be flexible work schedules or leave policies if somebody needs to go to a treatment facility. You might be able to do some job bundling so that, you know, that at safety sensitive positions might be taken away and put with somebody else. And you might be able to reassign a person to a position with fewer safety risks. There might be scheduling changes to allow for treatments or appointments. You could do a return to work program on an ease back and slowly move the people back into their regular jobs that have more and more exposure to those safety sensitive job duties. You might allow people to shift from full-time to part-time and back again, and referring always to EAP programs, other counseling, addictions, etc. Working with doctors, getting right information, and trying to, like I said, deal with people with dignity and respect. Undue hardship, everybody always wants to know what that is. I can't always tell you. It really, really depends. And I know Paula is going to talk a little bit about the case law and give you some guidance with respect to that. But for us, you know, everything is different. Every case is different, and it may include any of these 5 factors set out by the Supreme Court of Canada. Oh, actually 6 factors, sorry. Some are more obvious and more important than others, but I list them all for your reference. They're financial costs, collective agreements, morale of other employees, the interchangeability of the workforce and facilities, the size of the organization, and in this case, the case law deals with really safety concerns. Now, the duty to accommodate ends if a person cannot perform the essential duties of their job, the bona fide occupational requirement, or they meet that undue hardship requirement to the employer. And I think Dennis talked about, the same example we always use about pilots. Obviously, you have to be able to have good vision and fly a plane, have all those sort of things. You can't be on anything that would impair your judgment or abilities to fly a plane. And that would be a bona fide occupational risk, and also probably undue hardship as far as meeting that safety sensitive position requirement. So some of the questions that we would want employers to ask if they're trying to go through the process of accommodating, because again, as I said, it's the procedural and the substantive. So even if you're on a heavy construction site and every position is, say, safety sensitive, we still want you to go through that process. It might be a short process, but you're still turning your mind to it and seeing if there's other possible things that that employee can do. So you're going to see first, can this employee do their current job? Yes or no? Can that job be modified? Yes or no? Is there another job suitable and available? Does that other job need to be modified? Can a new position be created? And that is, of course, to the point of undue hardship. So there's no need to create work for people. Really, it's about collective agreement kind of conditions. Is there any extra training that might need to be done? And is there a requirement for that new position? Like if you're trying to create and fill a position and this person can be moved out of a safety sensitive position and put into this, and there's no kind of collective agreement concerns, and the person is perfectly suited for this job, then that might be a reasonable accommodation. This is just some kind of best practices advice that we give to employers. We want you to have a clear policy on the use of cannabis and other drugs in the workplace. You want to be able to specify very clearly, it's zero tolerance and what that means, or you cannot use legal cannabis 1 week before arriving on the site. Whatever it is, it's got to be as specific as possible so that there's no sort of area of confusion or misunderstandings. Be aware when you're dealing with people who have addictions that there may be a risk of denial. So train your HR staff in addictions and how to deal with those how to ask those questions in a respectful and sensitive sort of way. Be aware of your duty to inquire about possible addictions if you're noticing not, behaviors, and that's the performance management piece. Does your workplace culture allow for discussion and disclosure? So we have a lot of cases where people will say, I didn't say anything because I knew that I would get fired immediately without any opportunity to have a discussion. So again, this is, like a higher level sort of piece of advice, is to make sure that your policies are clear, your HR people are respectful, your workplace culture, as best as you can, makes it safe, I guess, for people to come forward to talk about issues, regardless, whether it's this area or any other sort of accommodation. You want to make people feel, your employees feel that if they come forward and say, I need this accommodation or I need this support, that you're going to listen and you're going to do your best to try and manage that situation. And as I said, overly onerous discipline will discourage self-disclosure, because we've had 3 or 4 where the people said, I didn't say anything because I knew that others had been fired right away. If there's no disability or addiction and they show up for work impaired, then you can performance manage as you normally would. So employees should talk to your doctor about your fitness for work, any negative effects on workplace health and safety, or the performance of your essential job duties. So that means you're going to have to cooperate in the process, get medical information if necessary, provide really, detailed information about the type of job that you do, so that your doctor or fit for work or whoever can make, good informed decisions about the need for your accommodation. I don't know if your family doctor is the best place to go, and I can say that because my husband is a family doctor, but they might have a role to play. We want people to talk about their accommodation needs. Like I said, you've got to participate in the accommodation process. You have to provide medical or other information to support a disability-related accommodation if required. You don't need to disclose your diagnosis, only your functional limitations. So sometimes it's a little bit different here. Obviously, you know, if you're saying you have a legal prescription for this, these are the limitations, but you might not need to say that the reason why I'm on this is because of PTSD or something. It really is just about your functional limitations. Now, I should have said this to the employers. When you're asking for medical information, you know, you don't need to go and find out every piece of medical information about this person's history. You're really just trying to find enough information in order for you to assess and consider all of the possible accommodations that might exist. And that's really it for me. You can contact us if at this information, follow us on Twitter. I think we have a guideline also on the use of cannabis on our website, thinkhumanrights.ca, and I'm happy to answer any of your questions later on. Thanks very much.
Great, thanks, Carrie. That was very, very interesting and informative. I think it's I find it interesting to listen to your discussion about accommodations, right? And really, how do we accommodate for individuals and really take both the employer and the employer's perspective in that. So that was great. I'm sure we'll have some questions about that soon. So before we get to the Q&A time, and as a reminder, please add your questions to the Q&A box as you think of them. And after Paula's finished, then we'll get to those questions. So our final speaker for this morning is Paula Shump. So she is General Counsel with the Newfoundland and Labrador Association of Public and Private Employees, otherwise known as NAPE, where she provides legal and strategic advice to the NAPE executive and provides advice on issues such as disability, workers' compensation, privacy, and human rights. So Paula also worked as Labor Relations Officer with the Newfoundland and Labrador Health Boards Association, and she served as the Vice President of the Canadian Association of Labor Lawyers in Newfoundland and Labrador. She holds a Bachelor of Business Administration from Acadia and a Bachelor of Laws from Dalhousie. So thanks, Paula, and I'll let you start sharing your screen. And we can't hear you. You have to unmute.
There we go. Everyone hear me now?
Yeah. Yeah,
Okay.
that's good.
Okay, let's see. I'm sharing my screen okay with everyone?
Yeah, that's perfect.
Good.
Thanks, Paula.
Okay, thank you. So good afternoon, everyone. I'm Paula Shump, I'm General Counsel with NAPE. So I'll be speaking about sort of cannabis in the unionized workplace and dealing with a couple of cases so that you can kind of see the practical realities of employer policies and accommodation issues that arise in the workplace, the unionized workplace in particular. So there are, of course, a few reasons why an employee may want to or need to use cannabis, and some of them are related to physical or mental health issues. And sometimes the use of cannabis is proven to be a very strong pain reducer for a number of individuals, and they find it enables them to keep working in the workplace, and it is so that they can focus on the tasks at hand, and it enables them to function in their daily lives as well. And then again, we just have some recreational users. So just as some of us go home and have a glass of wine or a beer on the weekend, or when we're socializing, some people like to relax and socialize with cannabis. And so we would call them, of course, the recreational users. So in a union, sometimes employers don't realize that we're often caught in a bit of a conundrum at times, because we have to represent sometimes both sides of an issue, or we have to choose between two sides of an issue sometimes. So when we're looking at an individual who requires cannabis in order to function in the workplace, we of course want to advocate for them and make sure that their rights are protected under the collective agreement that they're operating under, as well as, of course, the human rights legislation that's applicable to them. On the flip side of that, we also have a duty that we owe to the co-workers of that individual. We want to make sure we're not putting anyone in harm's way, and that, you know, if we're dealing with a safety sensitive work environment, that that individual isn't going to pose an undue risk to their co-workers. So the first case I'd like to talk to you about is with respect to a disability accommodation type case. So it involved the IBEW, Local 1620, and Lower Churchill Transmission Construction Employers Association. This is a 2020 decision from the Court of Appeals, so it's pretty fresh. And in this case, we had an individual who was prescribed medical cannabis. He had worked at the safety-sensitive Muskrat Falls construction site for 15 months without issue. His work record was impeccable. There were no safety issues or concerns. There were no concerns about him being under the influence of any substances. So everything was going fine. But then there was a shortage of work with the particular contractor he was working with. So there were a number of contractors on the site, and they all belonged to this employers association. So he went out and he sought employment as a laborer with another contractor. But because of his prescription for medical cannabis, he was refused employment because they felt he would pose a safety risk in the workplace. So the case went to arbitration, and arbitrator John Royal, I believe it was, agreed with the employer that the position was indeed safety sensitive. As a laborer, he could be operating heavy equipment or machinery, and that could potentially pose a risk to others in the workplace. The only restriction with respect to his medical cannabis that had been imposed on the griever by his doctor was that he was to refrain from operating a motorized vehicle within 4 hours of ingestion. So because he was using as vaping method of taking his cannabis, the restriction was 4 hours. I believe with ingesting edibles, it's 6 hours. So the arbitrator in this case concluded that because there was a risk of the griever being impaired while working, and there was no available technology to actually measure impairment, because that's the thing we have with cannabis is even though it can be detected in your system, it doesn't necessarily mean that you are impaired at that time, unlike alcohol, where we have a reliable scientific method to demonstrate impairment through a breathalyzer. So the arbitrator said that the inability to, or the lack of technology to accurately measure impairment actually created an undue hardship for the employer, and so the employer wasn't obligated to employ the griever. So that decision was then, the union sought a judicial review of that decision at the Supreme Court, and the judge reviewed the arbitrator's decision on the standard of reasonableness and found that the arbitrator's decision was indeed reasonable. That decision was then, so the Supreme Court decision was then appealed to the Court of Appeal in Newfoundland and Labrador, and the Court of Appeal had a different take on it. They thought that the arbitrator's analysis in the case was incomplete. He said it wasn't enough to just say, well, throw up your hands, there's no test for it to measure impairment with cannabis, so, you know, we don't have to accommodate. That wasn't far enough. The employer had to demonstrate that to assess the griever by another method, some other means, would create undue hardship. So the questions that, and Carrie touched on a number of these in her presentation, but the questions in this particular case, in the circumstances of this particular case, the court outlined some of the questions that the employer should have asked before denying the griever his employment. They should have looked at, well, was there a scientific or medical, was the scientific or medical standard test the only way to assess impairment of this particular individual? And if so, why? What about a functional assessment of the griever before the start of a shift? Could that have been an option? And if not, why not? What about other measures that could be undertaken, such as requiring the griever to report any dosage increases in his cannabis prescription? What about random independent medical evaluations? What about assignment to a lower risk area to minimize the risk? What about closer supervision of the griever so that, you know, any obvious signs could be acted upon? Any signs of impairment could be acted upon. So the Court of Appeal thought the best approach here was to refer the matter back to the same arbitrator for consideration of whether there was an alternative option for individual assessment of the griever to determine fitness for work. So I guess the big takeaway from this case is that every case is going to be individualized, and we have to really consider the individual, consider the nature of the job, and think outside of the box as to what can be done to keep this person in the workplace. But those are different considerations. That's when we're dealing with an accommodation in a unionized workplace. But when we're dealing with recreational users of cannabis in the workplace, in a safety-sensitive workplace, then different considerations apply. The employer is not held to the same sort of standard, of course. So the next case that I have up on the screen here is Steel Workers Local 9508 and Valet, Newfoundland and Labrador. It was a 2019 arbitration decision from arbitrator Jim Oakley. And in this case, we had a griever who was a recreational cannabis user. He denied having any sort of addiction type issues or substance dependency. And he was working as an operator at the concentrator mill in Voisey's Bay, Labrador. While he was working, he didn't follow sort of the pre-checks that are normally required for operating the crane, which, you know, were well established, and he was aware of that they were required. So he didn't follow the employer policies and procedures. And when he moved the crane, he ended up causing a lot of damage. He thought sort of the ball was stuck and he moved it back and forth. And so he caused some damage to the crane and some damage to the structure itself. But fortunately, it wasn't catastrophic. And fortunately, no one was in the vicinity when the ball was sort of released and damaged the walls. So that was the good news. But of course, there was a significant potential for harm in this case. There could have been significantly greater physical damage, as well as, of course, potential loss of life from his actions. So because of the seriousness of the incident, and this was a case, of course, where the employer had a drug and alcohol policy in place. And when they looked at the incident, the supervisor looked at it and said, well, this is a very serious incident, and there appeared to be no other factors other than human error to blame, because they determined that the operator did not follow the policy and procedure. There was no mechanical issues here. There was no one else involved that could have contributed to the accident. So the employer followed the policy, consulted with another management employee, another management personnel, and they concluded that it was appropriate to administer a drug and alcohol test in accordance with the policy. So in this case, when they tested the griever's urine, there was found to be 253 nanograms per milliliter of marijuana metabolite, and the policy cutoff was 15 nanograms per milliliter. The employer in this case called an expert in cannabis, Dr. Melissa Snyder Adler, and she was qualified as an expert in cannabis drug testing and understanding cannabis and its effect on fitness to work. Her evidence was that, of course, you know, cannabis I think we all know, is very dependent upon a number of different factors. And of course, it's not very clear as to how somebody will be affected by consuming cannabis. It depends on their gender, their age, the concentration of the THC in the product they've ingested, the quantity of THC consumed, their history of use, Apparently their age of initial use can affect how cannabis affects them. The frequency of usage and the last time that the individual actually used cannabis. So it's an educational case to read because this expert testified that, of course, the effects are different for each person, and it's difficult to predict how someone will react or respond to consuming cannabis. And she also pointed out that there can be withdrawal effects for regular users who stop taking cannabis. And these can be negative effects on attention and concentration, decision-making, and risk-taking. And she noted that some marijuana users have continued to make errors on tasks without awareness of the errors 24 hours after usage. Now, of course, that will vary individual to individual. Some will, some are in that category and others are not. So how do we know? She also pointed out that the effects on fitness to work include negative impacts on reaction time, divided attention, and negative effects on decision-making with respect to ingesting cannabis. She said that infrequent users can be impaired for a couple of days after usage, and heavy users can continue to be impaired after usage for 4 weeks or up to 6 weeks for a heavy user. I found that very interesting, certainly. I didn't realize it could be that extensive. In this case, this particular griever had been using marijuana for a period of over 11 years. And he worked 2 weeks on, 2 weeks off in this safety sensitive environment. When he was off shift, he'd be consuming 1 gram a day and then no consumption for the other 2 weeks. In this case, he was tested about 10 or 12 days after his last ingestion of cannabis. And with the level of marijuana metabolite in his urine, she stated, it was her opinion, that that would indicate an issue for fitness to work in a safety sensitive environment. The griever, she speculated that the griever could constantly have THC in a system, and if he stopped using, she opined that he would likely have withdrawal symptoms, so affecting his concentration and those such things. In this decision, the arbitrator looked at it and said, well, in this case, the employer complied with its policy. It met that threshold level to justify testing. There was a serious incident. There was no mechanical explanation or other explanation for the incident. It was human error, and it was there was a necessary connection, therefore, between the griever's actions and the consequences, the incident itself. The arbitrator referred to other arbitration awards, and he concluded that, of course, a positive test for marijuana metabolite doesn't prove impairment. However, and I thought this was interesting, he said, he mentioned it in passing, he didn't really expand on it a lot, but he said that the policy in question referred to under the influence and not impairment. So that suggests that it's a lower standard, would result in an employee's breach of the policy. And he also went on to state that the expert evidence supported the standard. That was a normal standard in the industry, and it was based upon on research and science in the field of research of cannabis. He indicated that the breach was serious because of the potential to harm, and therefore the employer had just cause to terminate employment. So some of the takeaways from all this is that the considerations differ when you're dealing with recreational cannabis use as opposed to use that's related to a disability. And of course, that's when the human rights analysis comes into play. Employer drug and alcohol policies, of course, will continue to be tested and must be reasonable in the unionized environment. And the analysis that I'm sure many of our employer reps on the call, if you're working in a unionized environment, I'm sure you're familiar with the KVP rules. A rule, an employer, unilaterally imposed employer rule can't be inconsistent with a collective agreement. It can't be unreasonable. It has to be clear and unequivocal. It must be brought to the attention of the employee before the company can act on it. And the employee concerned must have been notified that a breach of the rule could result in discharge if that is a foundation for the discharge. unilaterally imposed policy of mandatory, random, and unannounced testing for all employees in a dangerous workplace is overwhelmingly rejected by arbitrators and courts alike as an affront to the dignity and privacy of employees. So random drug testing is out the window. There has to be reasonable grounds. The dangerousness of the workplace is only justified the testing of particular employees in certain circumstances, and again, where there are reasonable grounds to believe the employee was impaired while on duty, where the employee was directly involved in a workplace accident or significant incident, or where the employee returns to work after treatment for substance abuse. So there you have it. That's my 2 cents worth on cannabis in the unionized workplace.
Yeah, thanks, Paula. Those great, and I really like your stories, right? I mean, I think it shows that how things are not black and white, right? There's so many different considerations, and hearing those stories are, I guess, bring forward a lot of questions that I have about how we can, accommodate and best consider those considerations. So I guess now we'll open up to some questions. I guess before we get started with some of the questions, and I have a lot here to go through, I guess do any of you have any comments to add about the other speakers now that you've all had a chance to speak? Anything else that you want to add or provide perspective on?
No, I just think a
Okay.
common theme is that we all have to, every case is different. And these lessons that we're talking about today and any of the questions that come out, from our perspective, we still want to see people go through a process. It might take 1 minute, it might take a week, but there's a process to be followed because every individual is different and every kind of workplace is different and every case is different. So that's the theme that I've heard from all three of us.
Yeah, I mean, that's so true, Carrie.
I would agree. Yeah.
Yeah, definitely. And I guess just to start off, I guess people are wondering now, since legalization, I mean, cannabis is in the public. I mean, we all encounter it more than we did before legalization. So in terms of, I guess, workplace, what changes have you seen in terms of concerns in the workplace? Like, have things changed much? Is there anything that's kind of, that happened kind of more initially, but now they're kind of evened out over time? Dennis, any thoughts on that to get started?
Yeah, it's a great question. I think back on the months leading up to legalization, and we expected a deluge really of all kinds of concerns, very complicated situations, but that really didn't materialize once we really came to the realization that this is just one more substance. Now, yes, it's legalized where it wasn't previously, but the employer had a prior duty to guard against impairments in the workplace. So it really just fit very much under existing steps that a workplace needs to take to ensure the health and safety of everyone at that workplace. So for us, we were very surprised that there was not more complexity and more, at least in terms of what we're seeing here from kind of an injury prevention perspective. Now, the thing I didn't really speak of in my own remarks was we also had to deal with the issue of whether or not we would cover medical use cannabis for workplace injuries. And that was a whole other debate we had because the cannabis is a bit different than most of the prescriptions that we would cover for an injured worker. And the guide we use is that, according to Health Canada, that medications would have a drug identification number, but cannabis doesn't have that, and it's not truly prescribed, as I understand it. It's more there's an issuance of a medical use authorization. So we did have to grapple a little bit with that, and I think Paula summed it up very well at the end, and Carrie as well. We've all talked about case by case basis. So you look at the merits of each individual case before you, whether it's an arbitration, whether it's something to do with a claim with Workplace NL, or potentially a complaint with the Human Rights Commission. I think that's the key takeaway, that there's so many individual circumstances you have to look, have the best guidance you can, but then make a decision based on the merits of that case before you.
And I guess just to carry on with that, do you anticipate any changes in the next, I guess, few years? I mean, we're 3 years out now from legalization. Do you see any other changes that may arise from this?
I guess
How
from
about
my...
you, Carrie?
Oh, yeah, go ahead. Sorry.
So, Carrie, do you have any thoughts on that?
Yeah, sure. So likewise, this happens all the time. Right now it's vaccine passports and masks, and there's a flurry of information, and people are all in a tizzy about things. And I mean, same thing happened with this issue of legalization. Also, we experienced this when gender identity and gender expression was added to the Human Rights Act. Everybody's all in a flurry, and I do a lot of these presentations, and then we have a few cases and then nothing. So I think employers have learned, I think employees have learned. There are processes in place. Still, one thing I'd say is pretty much every company has a policy, but where things break down and whatever the issue is and how that policy is plays out. So it doesn't matter your policies, that's all great. It's about the training, it's about supporting your staff, it's about all these different things. The one thing I might see, as you know, and I don't know all the details about the types of drugs and the percentages and this and that. When you read some of the cases, it's like you need to be a doctor or a pharmacist to really understand some of the stuff they're talking about. And that's why I went to law school. So I that's not kind of where my strengths lie, but maybe there'll be faster testing. Maybe it'll be a different sort of process. So, we talk about with COVID rapid tests right now. So you go onto a site and that's what happens. I know random or this or that or whatever, but there might be different ways of dealing with that and different ways of, science will evolve. So you'll be able to tell, much like blood alcohol level, where kind of people fall on that scale of impairment, because I think that's the concern, right? Impairment, bad. We all know that. But how much do you have to ingest or smoke or do whatever, take a pill? I don't know. How much do you need to take in order for you to be impaired? So those might be new changes coming in the workplaces. But I know, a couple of years ago when this happened, they were talking about how expensive that was and the technology didn't exist. I don't know what's happened now. Maybe that's happening. And I suppose, market forces will make that happen sooner rather than later.
And I think there's still sort of a residual stigma attached to cannabis use. Like, some people think, oh, it's just potheads that use cannabis or whatever. But, it does have a very real therapeutic effect. And we're starting to see, it seems to me that medical cannabis is becoming a bit more commonplace and accepted. And so, but still in some workplaces, it seems to be treated a bit differently than other medications that somebody would take that could potentially cause impairment. There seems to be a hyper focus on cannabis, and perhaps that stems from the history of the cannabis being illegal and such. But and with respect to cannabis in the workplace and the designation of safety sensitive workplaces, an employer just can't say, oh, people are operating equipment here, it's safety sensitive, and therefore there's no use of cannabis permitted or what have you. And we've kind of been having a bit of that experience in our membership, with a couple of employers sort of designating everything as a safety sensitive position. But when you look at it, we're not talking about big construction sites. We're talking about little private industries that, you have to look a bit closer. So I think we're probably going to see some challenges to employer policies and application in those areas.
No, lots of great points. I got lots of follow-up questions to that. Carrie, you want to comment?
Yeah, I just wanted to say on our website, thinkhumanrights.ca, we have a recent case from last year, I think, and exactly what Paula was talking about. The person was a nurse manager or something and had something to do with the industrial site, but the Human Rights Tribunal basically said this position was not safety sensitive. And what they were doing was saying anybody associated with this site was considered safety sensitive. The other interesting thing from that case, and it also touches on something Paula said, is this person had gone through, I think they had Ewing sarcoma with a lot of heavy duty cancer treatments and was suffering from chronic pain. So you're right, it's not just the quote unquote potheads who are doing this. This was a legitimate pain relief for this person. So, I think that's going to evolve our understanding of what this means. Last thing I'd say is we had another case years ago where the person had like a chronic pain sort of issue, and they had worked with their physician for a number of years to try all these sorts of pharmaceuticals, like legitimate drugs, prescribed drugs, and all of them caused serious side effects. The employer knew about it. They worked with this person. They felt bad because I think maybe it was cancer or something like that. So there's no stigma associated with cancer and cancer treatment. The employer felt bad, wanted to make sure that this person was well taken care of, and but had no problem with this person working in a safety sensitive position while on this drug prescribed by a doctor. After working through this and saying all of these drugs are horrible with the side effects, finally coming to the conclusion that medical marijuana was the right fit for this person, suffered less impairment, better pain management, the employer said, no, you can't work here anymore. Meanwhile, they've been driving or whatever using opioids. I don't know what they were on, but something that caused real side effects, but was seen as, in the employer's mind, a much more legitimate somehow medication to treat whatever the problem was. So just a few points there.
And that's an excellent point. And one of the questions that we had was around policies around opioids or other drugs, right? So are there policies for these other drugs, like you just mentioned, Carrie? And then, are those policies different than for, people who use cannabis, whether it's medical cannabis or they're using it for non-medical purposes?
Yeah,
So
I think there are obviously policies. I think what the difference is the application of that policy. Because they felt it was a legitimate drug, they felt bad for this person, they wanted to work with them. He had a legitimate injury. It wasn't just, anxiety or whatever. It was cancer or chronic this or that or some serious illness, disability. The application of the policy was different for this person using synthetic drugs versus medical cannabis.
Yeah, no, that's a good point. And another comment we had is that medical cannabis is prescribed sometimes for indications when there's little or no evidence to support its use, right? So I'm thinking about the whole potential risks and the employment perspective, then when you're actually hiring someone and you're questioning whether it should be used to begin with. So I mean, that's a comment. I'm not sure if there's anything that at an employer level that you can do about that. Anyone have any comment around that?
Are they talking about pre-screening, pre-employment screening? Is that what?
It didn't specify, but I guess if you have whether it's a new employee or someone who's already working for you, and cannabis could be prescribed, and I guess it's questionable how great the evidence is. And in another situation as well is people who are basically recommended for medical cannabis, but they can't afford to purchase medical cannabis, so they're buying the non-medical supply. Like, is there any of that that's considered? Does it have to be the medical cannabis? How deep are the policies in terms of, I guess, monitoring that or assessing that for people.
Yeah.
Paula, you have any thoughts on that initially?
Yeah, I think wading into that is going to be challenging, because if it's not prescribed by a physician, and it can't be, you don't know what dosage or concentration you're getting, or, you know, the particular makeup. So I don't, you know, I think it would be more difficult for an employee to, again, though it comes down to impairment, and I guess what the evidence is as to what that person requires in order to be able to function at work. And, you know, it'll, again, it's one of those case by case assessments as to what's the need and what are the particular circumstances of the individual, and is there a way to minimize risk in the workplace if we're talking about again, I'm assuming we're talking about a safety sensitive workplace.
Yeah. Oh, Carrie, did you have something to add?
Yeah, that's an interesting question, because you know, I knew this person who had gone through cancer treatments, and they were given all these drugs, and the same thing, like Paula just said, the doctors wouldn't allow them to go and get their own marijuana, you know, not medicinal marijuana, but just from, you know, their source, and whatever you want to call it. And the doctors were really against that because they didn't know the dosage and this and that. But I think, you know, maybe with better testing of impairment, that might solve a lot of those problems, because I think, you know, people might not be able to afford it, or it's too difficult, or they're not in a place now with family doctors that they can easily access this sort of service. So it's really about, like a lot of other accommodations questions, about the functional limitations, the impairment on the person and their ability to do the job, rather than what their problem is, what drugs they're on, what this, what that, whatever. So I think it's about focusing on that part, rather than kind of getting caught up whether they're having legally prescribed drugs or from their local source.
And one person also commented around, I mean, we had several questions here about testing, right? So that's a big question. And Paula, you demonstrated that in some of your examples that you gave, right? So how do you actually interpret that number? Because impairment is different from in everybody. So I guess are workplaces looking around more of measuring impairment instead of, I guess, quantifying in terms of, you know, usage or, you know, blood levels, anything like that, urine tests? Any, I guess, thoughts around, I mean, how do we look at usage or impairment and interpreting that in a workplace versus trying to quantify that?
It might
Any
be
thoughts, Paula?
it might be a case where, you know, occupational therapists are trained to assess people for different levels of function. Usually we're talking about physical function, but perhaps there's a way to design a test that would sort of reasonably replicate the requirements of a job, and, you know, and have you set that as a test for impairment. I don't know if it's reaction time, you know, hitting buttons or something. I'm just thinking off the top of my head. You know, we have to turn our minds to, okay, if there's no test available, then how else can we test for impairment? And, you know, there's always the roadside, you know, walking the straight line, you know, finger to the nose, those sorts of things when you're testing for alcohol too. Maybe that also would measure impairment for cannabis. I know reaction time seems to be a big concern with respect to, you know, impairing function in cannabis use. So maybe there's a simple little test, not expensive, that could be easily administered periodically to assess a person's level of function.
Yeah, there
And
are
so
tests already, sorry about that, for impairment. Police and all those things, they know that already. It's really about getting that knowledge in some sort of simplified way to frontline people on these sites, so that they can do it in kind of real time.
yeah, because it is. I mean, just measuring the THC is not really telling you much about the impairment, or it's only one component of that, right? So it all needs to be put into context. And how do, I guess, employers use that, and how they can incorporate more of the impairment considerations. And then someone else just asked around CBD. So CBD doesn't have the same type of impairment as THC. So some people are taking CBD for medical purposes. So how does that fit into workplace testing and usage? I don't know if any of you have encountered that. Have any thoughts?
We've
I
had
haven't-
nobody, coming saying we want to file a complaint because they're on CBD, but I think, like we've all said, it's about the impairment, whatever drug you're on, right? Sorry, go ahead, Paula.
Oh, sorry, I didn't mean to interrupt you, Carrie. And it seems that the testing is testing for THC levels, which,
Yeah.
if you're strictly CBD, then I would presume there's little to no THC in it. I know you can get combination ones, but I would think that it shouldn't show up in any sort of testing if you are strictly CBD, or the level should be below the threshold.
Yeah.
Yeah, it hasn't been an issue for Workplace NL to date. And I do agree, it's really about the level of impairment versus the source. And I think Carrie said it well, over time as testing evolves, we need to get the degree of accuracy. Right now, we're sort of grappling with various means, the roadside test that Paula mentioned and others. And that's really, if there's a way to get that simplified for workplaces and job sites, specifically those, or especially those that have safety sensitive operations, that's the direction we need to continue to push in.
Yeah, no, definitely. And I'm just looking at some of the other questions here that are coming through. I guess for Carrie in particular, what are some reasonable next steps once accommodations are not effective? So once you kind of try to make those accommodations and they're not effective, what can, I guess, employers do?
Well, again, like it's a high burden, right? So it's to the point of undue hardship. So that's not just, oh, sorry, there's nothing else we can do for you. The cases Paula talked about, they had to go and like examine other positions, look at their whole workforce, look at the job duties, do all these sorts of things. But ultimately, there are instances where employers do meet that burden, that heavy burden. And so what can be done? Sometimes it's unpaid leave, sometimes it's termination because you're not able to fulfill the legitimate job duties that's required of you. So that's just, basic kind of contract employment law there. But it's maybe in this situation, because if you're, a forklift operator on a remote northern site with no other jobs available, you may not be able to work at that site. But maybe there's something else at the head office here in St. John's you might be able to do. It really, really depends. You might be able to, I don't know, maybe they do training and instructing of people and you could be setting that up or doing something else. Like you really have to be creative and think, I hate the phrase think outside the box, but it's just really the only one that I can think of. And that's really what we would suggest people do. But at the end of the day, you may not be able to do anything. But the biggest thing is to demonstrate that you've looked at every single option. You've included the employee, you've treated with them with respect, and maybe sometimes if you followed the right process, that employee might say, walk away. And this happens. The employee walks away and says, no, this is not the job for me anymore. And maybe you might want to even include retraining or something. There might be other options there. They walk away, there's no human rights complaint, everybody's happy. Doesn't happen all the time because we're all human beings, but that's the ideal kind of goal that we're all striving for.
Yeah. And I mean, that accommodations is so important, right? So thinking, like you said, outside the box, like what else can that individual do? No, that's definitely important. So I guess I heard from I guess, Carrie, you were talking about, I guess, that workplace culture and people feeling safe to even discuss it, right? And I think, Paula, you talked about some stigma as well. You know, there is still a lot of stigma around cannabis and people being afraid to come forward and talk about it. I guess, do you have any thoughts around what we can do to help combat stigma at the workplace and making people more comfortable coming forward and having those discussions? Dennis, any thoughts from you to start?
Yeah, well, given the mandate we have around education and awareness building and prevention, that is something that we play a role in, and it is just that, trying to create and advance an awareness that, you know, that over time one would hope that stigma that Paula spoke about is going to be minimized, and it becomes, you know, part of sort of day-to-day societal life, that, you know, there are going to be people who are legally using cannabis in a recreational form. Some have to use it for medical purposes, and it's continuing on that journey to continue to promote and create education. You know, sessions like this today will help spread that particular information to get into the right hands, and over time you just sort of aim for a goal that you know, people are going to get over that concern that they've had around such stigmas. But, you know, a lot of these are ingrained. They're in an organization's culture, and it takes a bit of work. So, but I would definitely advocate for continuing that type of awareness campaign to minimize those stigmas.
Any other thoughts, Paula, from your perspective?
It really comes down to education. And I think as time goes on and more people are prescribed medical cannabis and, you know, seeing the value of it, or their relatives are using it and getting value from it, you know, I think it will normalize a little bit more. But I think it's just going to take time and education, like Dennis touched on.
Yes. And
I
even
think
thinking,
it's
I guess,
sorry.
oh, Carrie, you go ahead.
No, sorry. It's hard to tell on this
I know.
all on these squares when I can talk. I think it's also part of a bigger, broader kind of culture change that we need to, you know, really consider, because it's not just this particular issue, it's mental health. It's, you know, a lot of other things that people need to remove. It's about anything, you know, coming out, sexual orientation, whatever it is. People need to feel, and I think better workplaces will demonstrate that they have a culture of inclusivity, respect, and dignity, and these things.
Yeah. And an audience member just comment that stigma is prevalent for all substances and mental health, like you just mentioned. And then we can perpetuate that by the language that we use and how we talk about things. And I think I've also noticed as well, a lot of people even who are using cannabis, you know, legally, it may not be for a medical purpose, but a lot of times, I guess in terms of stigma, it's almost that they try to justify by adding in, oh, I need it for this particular condition, or I'm using it for this reason to make it more acceptable. Right. So not like alcohol, you know, people have a drink and they don't feel the need to justify it. So, you know, it's just that culture. And I think like Dennis, you said, is that it's just that culture that we're in and it's ingrained. So how do we change that? And at the workplace, people are afraid, right? Because they know there's policies, they know that they may be penalized or maybe, you know, things that happen that they don't want. So that's definitely a concern. And I guess any advice to employers to make it more kind of, they can be more open and really encouraging their employees to come forward and have those discussions. One person also mentioned in the Q&A is that people use other recreational or medical cannabis can meet the criteria for a substance use disorder. And this could impact the duty to accommodate. that wasn't a question, it was more of a statement. And I guess, Carrie, from your point of view about that duty to accommodate, if they do have an actual substance use disorder, are there different considerations there?
My dog is right beside me. It's really noisy. Sorry. What was I going to say? So no, it's the same accommodation process, right? If that's the disability or the diagnosis or whatever it is, I think there might be different limitations. There might be functional limitations, depending on whether it's chronic pain. Well, no, sorry. The functional limitations will be the same if you're using the same cannabis. But so to me, it's not about the need or why or what the issue is or the diagnosis. It's about the functional limitations caused by the drug that you're taking, whatever that is. There may be other supports. Say if it's an addictions issue, I don't know what this disorder is, but say if it's an addictions issue, you may be required as an employer to provide other sort of recovery addiction support in addition to measuring and dealing with the functional limitations issue.
Right. And that's a good point, because there is a lot of stigma for addictions as well, right? So people who have substance use disorder, whether it's cannabis or other substances, and then what is our duty then to accommodate and to support those individuals? So that's important. Someone asked if there was, I guess, examples of workplace policies regarding cannabis, even different examples based on the risk level in the workplace. We've heard a lot about kind of high risk places, but also there's more kind of lower risk working environments. So I guess, are there publicly available workplace policies that people can access?
Yeah, like on Google, you just Google it, right? But again, it's about your policies are about making sure that it's appropriate for your individual workplace. And even I work in an office, you're all in offices, I'm in my house, but right, just today, it's quieter here except for the dog. But if you're in a workplace and you show up impaired, there's going to be consequences of that, right? There may not be as many safety risks, but maybe there is if you're driving to work or you're doing something or whatever it is. So it really is about having a policy that's broad enough to cover all sorts of situations, but also specific enough, if that makes any sense, to really give people good information about what they need to do in their particular work environment.
And I could add to that, from at least an OH&S perspective, we have safety advisors on staff at Workplace NL who work with employers all the time on helping them build their workplace health and safety programs, which do incorporate things around impairment at work and things of that nature. So I would throw it out to the participants as well, that we can provide assistance if anyone has a particular type of issue they want help with around policy development as it relates to impairment for cannabis, alcohol, other reasons. And we do that on a fairly regular basis with employers. And we tend to encourage them to incorporate that into their existing health and safety programs, or to develop one if they, for some reason, don't have one already in place.
No, that's great, Dennis. Oh, go ahead, Paula.
And when you're talking about, a drug policy that incorporates testing, you have to recognize that that's a significant intrusion upon privacy rights, and only in limited circumstances in a unionized context can you have a policy that enables an employer to demand testing of an employee, typically where there's, evidence of substance abuse problem in the workplace, or you're dealing with a safety sensitive workplace. So it's, if you're not in a safety sensitive industry, you may not be able to have that component into your policy about not random drug testing, but cause for testing employees, because it's such a significant intrusion upon privacy rights and security of the person.
We do have a comment from someone I guess in follow-up to that, so if the police are able to detect impaired driving with cannabis for everyday drivers, why isn't the same method adopted or accepted in the workplace for cannabis to detect if an employee is impaired at work?
I heard a couple years ago this came up when this became legal, and it's about the cost of training the people to actually really truly understand how to do this properly, and not just making sort of stereotypical assumptions about how a person is behaving. But the police go through a lot of intensive training. Now, again, that may change and become a lot cheaper as more and more companies realize the importance of this. And then the only thing I'd add is once you're training people, whoever it is, security even, or people, you know, I don't know who, it depends on how your workplace is set up, is what do they do after the fact, right? What do they do once they find somebody? And a lot of times frontline workers don't really know what to do. So right now with all the masks and vaccine stuff, they know what the rules are, but they don't know what to do if somebody comes in and says, I can't come in, or I have an exemption. And that's where things break down. So it's really about training and supporting those people who are making those sorts of assessments.
And I guess it comes down to, are there any human rights concerns by testing people at work? Right, so one of it, obviously you have to be trained and know how to interpret whatever you're using, so the particular test and or assessment. But yeah, are there any, I guess, human rights concerns there?
Well, I think like Paula said, I mean, just, you know, you've got to have some sort of need, reasonable need for doing this. If there's no problems with drug or alcohol on a site, you know, it's not going to be reasonable to do that. Whether it's a human rights issue or a collective agreement or privacy or whatever it is, there's really, you know, that's what the courts are going to look at. Why are you doing this? And is it necessary? And is it reasonable enough in, you know, to intrude on people's personal information, privacy, medical information, all this sort of stuff. I'm curious as an aside, because I'm really intrigued with all this vaccine passport stuff. What's going to happen there? Like, is that going to, I don't know how to phrase this, but is that going to, and I mean, I suppose this is why people are kind of one of the reasons why people are upset about it is because they're going to think that maybe this is going to move us to a place where this sort of testing, for a lot of different reasons, is totally normal. And what does that mean for privacy, for human rights, for a lot of different reasons? I just put it out there.
Yeah, that's definitely food for thought. For sure. I just want to go back to, I guess, what Dennis said earlier about, I guess, supporting people in terms of policies and things, which is great. And in particular, I see this for small businesses, you know, some of the smaller companies that needs more support, how useful that would be. And I guess one question that we have here is around employers that may not have a policy in place, or they don't have a policy in place. Do they have a right to take action in situations where cannabis has impacted someone's ability to work? So are there any protection for employers, you know, if they don't have a policy in place?
Well, I can offer that employees, generally speaking, and workers, but employees have to ensure a safe workplace. So whether they have a policy in place or not, if there is some form of risk, and it sounds like this question is really focused on some impairment issue that's causing an issue in the workplace, whether the employer recognizes it or understands it or not, there is a duty explicit already in existing legislation to provide a healthy and safe work environment for his or her employees. So there would be, you know, if something does go wrong, there would be an investigation, and you know, it'd be judged accordingly whether or not the right steps were taken. So I'm not sure if it's so much a protection as there is a duty to ensure a healthy and safe workplace.
And I think, you know, it's like any other employee discipline type issue, whether they're not doing their job because they just don't feel like it, for example, if somebody's not a productive worker for whatever reason. I mean, if it's not related to a disability, you know, the cannabis use, if it's a recreational user, then it really becomes a job performance issue, regardless of the cause of the performance. And the employer can take whatever disciplinary measures, you know, may be indicated.
Right. And I guess there's also, I guess, concerns, and Paul, you talked a lot from the union perspective. So there's concerns from people who don't work in a unionized environment, and they may not feel as protected. So there, I guess, any thoughts or advice for, I guess, employees who may not be in that environment and not feeling as safe coming forward or disclosing their cannabis use?
Well, they have the same protections, you know, under the Human Rights Act that unionized employees have. It's perhaps the recreational user that maybe can possibly be a little bit more protected under a unionized environment, because we have the ability to challenge employer policies and such. But with respect to human rights protections, they're equivalent whether you're unionized or not.
Right. I guess people may not feel that way, but that's a good point. And that was another question I had, is who has access to the services from the Human Rights Commission? So Carrie, I don't know if you want to explain that a
answer
little bit.
that. Considering I work there, anybody in the province, as long as it's a provincially regulated business, service provider, whatever. So the head office can be in Calgary, but if you're working here, it's the same thing. And it happened within the last year. So you have to call us. There's a 1-year limitation period. Contact us. We have an online application form. So if you're curious whether or not what happened to you might fall under the jurisdiction of the Human Rights Commission, fill out one of our online application forms on our website. And it walks you through kind of the legal requirements in order to file a complaint. But yeah, anybody in the province who thinks they've had an issue, if you even want to just speak to our intake officer, you know, they might be able to help you if you're approaching your employer with the request for an accommodation and you're not sure how to ask for it or what to say, or if you're in a non-unionized environment and you don't have that resource. Our intake officer can help you kind of just talk it out a bit and discuss how you would approach an employer, what type of medical information you might need, if you need any at that point. And tell people that you are required to participate. We have a lot of people who phone and say, I want an accommodation, but they don't really participate. They refuse to give that sort of medical information because, you know, I understand, like they feel like that's my personal information. My employer doesn't have a requirement. It doesn't get that information from me. But as I said earlier, it's about enough information to allow your employer to assess the need. And so it's really only about functional limitations. So if an employer does ask you for, I need all your medicals, then how do you respond to that? So again, we can talk about those things with people as well.
Yeah. No, that's very helpful. And it's good for people to know that they have that support there. All right, I'm just scanning down through the questions now to see if there's anything else that came up, but I think you covered off most things. I mean, a lot about testing and measuring impairment. That's a concern for people, of course. I guess, I mean, it's 1:30 now. This has been very helpful. Before we close up, do you have any, I guess, last thoughts or comments that you want to share?
I guess I have a very quick one. It's not okay to be high at work. I was going to sum up everything I've spoken about. That's the campaign we launched 3 years ago now.
Yeah, no, that's great. That's a great kind of take home message there. And, you know,
just don't be impaired at work. Like, don't go to work impaired. It's pretty simple. It's the same with alcohol. Like, you know, when employers were calling us when this happened, what do we do? Oh my God, drugs. But But really, like I said, how do you manage if somebody shows up under the influence of alcohol? Well, they had a whole process. So I said, it's the same thing. You know, there may be other training and testing and this and that and whatever, but really nothing has fundamentally changed. As an employee, you're required to show up to work, not be impaired, and do your job. And so that's what's required of us as employees. So listen to Dennis.
So true.
Drugs.
Yes. Paula, any thoughts from you?
I would just say there's no cookie cutter solutions for accommodations, that everybody has, every circumstance is going to be different and there are going to be different considerations. So be aware of the individual nature of accommodations.
Yes. Excellent point. So thanks, Dennis, Carrie, and Paula, for taking the time today to speak with us, to share all your insights and thoughts. I think we've all learned a lot from your experiences and your input. And thanks everyone who attended. We can see you face to face, but we know you're there in the background, and for all your questions that you put forward. So that really helped with the discussion. So please check out our website for more on our upcoming events, and for the video for our first webinar, which was on access to safe cannabis. And then in the upcoming days, we'll have a recording of this video as well. So we have 2 more sessions upcoming, and they're held every second Wednesday. So the next one's on cannabis use and driving, and the final one's on information about medical cannabis for healthcare professionals. We also have some great information and resources available on our website, so please feel free to check that out. And we'd love to hear your thoughts about this session and your ideas for future sessions. So you will receive an email link to a feedback form, and I believe we'll post the link as well in the chat section if you'd like to complete the feedback right away. So thanks so much for everyone for attending, and we hope to see you at our next sessions. And thanks again to our great panelists for taking the time to share with us today. So thanks everyone.
Thank you.
Thanks.